In today's courtroom drama, a defendant faces down a massive $32,000 theft, a judge ready to drop the hammer, and a probation deal that could either save him or break him. But here's the kicker. With impossible monthly payments hanging over his head, one wrong move could send him straight to prison. Stay tuned, because this case has shocking twists you won't see coming. And hey, if you love real courtroom breakdowns like this, make sure to hit subscribe so you never miss the next jaw-dropping trial.
That's Mr. Grove. Have you talked to him at all? Okay, let's wait. It should be Alan Lofton. Are you here? And again, that's your lawyer as well. You haven't seen him, have you? No. All right. Y'all ready? No. Andre Guillory?
Yes, sir.
Notice how the defendant is not even sure where his lawyer is? In a courtroom, that's already a red flag. Having legal counsel present is not just formality. It's the only shield between him and a harsh sentence. Imagine walking into a gunfight without a bulletproof vest.
(22-40681) is called. Andre Jamal Guillory, present with Mr. LeBlanc, his attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that from on or about September 1st, 2021, and continuing to on or about July 27th, 2022, about a year, this states that you committed the third-degree felony of theft. Do you understand what you are charged with?
Yes, sir.
This is theft of money. Looks like.
Yes, Your Honor.
What was that?
It was $32,831.02 from Cracker Barrel here in Beaumont.
Did you work there?
Yes, sir.
Oh, okay. It's not a good thing.
Over $32,000 stolen from a Cracker Barrel. That's not just a side hustle. That's a felony buffet. And notice the judge's dry, it's not a good thing. Translation, he's in deep trouble.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement has been reached in your case where you would be pleading guilty based on deferred or unadjudicated probation for up to 10 years in length.
Yeah.
You must pay restitution in the amount of $32,831.02 to Cracker Barrel in Beaumont. Is that your understanding of the agreement?
Yes, sir.
There will be terms and conditions of probation which are normal and customary for this, including, like the guy before, like theft prevention.
Here's the twist. Instead of prison, the defendant is offered deferred adjudication. Think of it as probation with a chance to wipe the slate clean if he follows the rules. But here's the catch. One slip up, and this deal vanishes like gravy at Sunday brunch.
Class that you must take. You know it's wrong, but we help burn it into your memory that it has consequences. If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Sir.
Show you what's marked as State's Exhibit 1. Help me. Did you sign that document? Voluntarily, understand it, discuss it with your attorney, and are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection, admitted. Among other things, the state you are mentally competent to enter your guilty plea. Freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offense. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer, all through, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report way?
Yes, we do.
Okay, I'm going to follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from your sworn admission of guilt here to find you guilty beyond a reasonable doubt. I now find I could find you guilty beyond a reasonable doubt at this time, but I am going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You do well, it gets shortened to 1/3 of that. The most important thing is this money that is owed. How is that going to be paid back and how much you're going to do per month?
As much as I can.
Then, I need a number. If you're unable to make it, we can amend it, but I need to know an idea because this is a lot of money.
So maybe you get up to 1,000 a month.
Where are you working now?
But right now, I do like odd jobs, and then I drive Uber too. And I make about 700 a week.
How much?
700 a week.
Okay. So that's 28. That's between 2,500. Why don't we do this? Well, why don't we start out with 1,250?
Okay.
Okay. And that still is per month is not going to get you. Can you do 1,500?
Yeah.
Okay. Then 15 gets you halfway in a year.
Okay, we go.
In the probation report, in this probation order, if we can change this when he signs it to a minimum of 1,500 per month to be paid back, and that still gives him 2 years. But I can tell you that the key also to getting off of probation early is.
And here's the financial reality check. $1,500 a month on an Uber driver's paycheck? That's brutal. Judges love restitution because it makes the victim whole. But for the defendant, it feels like paying rent on a second apartment he'll never live in.
It's good behavior, but when you pay restitution back, that means a big difference to me and the victim, and you get rewarded. You sense what I'm telling you?
Yes, sir.
Is it reaching out there because I'm telepathizing?
Yes, sir.
Okay. All right. Please see the probation officer. Thank you.